You know that feeling when you see something online? It looks incredible, like top-of-the-line quality. And then what actually shows up in the mail is, well, it's not that.
The classic expectation versus reality gap.
Yeah, exactly. And today we're applying that to something with much higher stakes, the legal world. We're doing a deep dive into the practice of California attorney Norman Gregory Fernandez. That's bar number 189402.
Right.
And what we found, looking at the state bar investigation, specifically matter 250-25680, is this massive disconnect between the marketing and the brutal reality of court records.
And this is such a cautionary tale. The mission here isn't really just about one lawyer. It's about understanding a systemic problem.
A bigger issue.
A much bigger issue. How do these high-volume legal practices hide serious systemic failures? And, you know, what happens when a flashy brand collides with the state bar's disciplinary system?
Let's start right there, with the brand. Because he's not just any lawyer, he's the biker lawyer.
Oh, yeah, the whole leather vest aesthetic. It's a very specific vibe.
It is. His website, injuredbikers.com. It's intense. It says he's nationally recognized, he has a perfect 10.0 AVVO rating, and he's selling this aggressive style.
You see the ad, you think you're hiring a pit bull.
Exactly. But then you look at the regulatory analysis at his actual litigation history, and you don't really see a pit bull. You see what the sources call a settlement mill.
Okay, so break that down for us. What does that term actually mean?
So a settlement mill is a firm built for pure volume, not necessarily for winning in court. Quantity over quality.
Precisely. They sign up hundreds of clients, hoping for quick, easy settlements. The problem is they often don't have the real infrastructure to fight if a case gets complicated.
So cases are getting, just dropped?
Worse, they're getting dismissed. Not because the case was weak, but because the lawyer just stopped working on it.
Seriously.
Look at the case of Rachel White v. Compton, USD. The court dismissed it for lack of prosecution. In plain English, that means the lawyer just didn't do anything to move it forward.
So the court just killed it.
They did. And it gets even more direct. In Connor v. Seitz, the record from the judge explicitly uses the word abandonment.
Wow. Abandonment. I mean, legally, that's got to hit California's Rule 1.3 on diligence, right? You can't just ghost your own client.
You can't. And this is where the irony gets really, really sharp. Because Fernandez markets himself as this tech guy.
Oh, right, the former engineer background.
Yeah, claims he was involved in early computer networking, so you'd think his office would be, you know, a well-oiled machine.
You'd expect flawless calendaring, perfect e-filing.
It works.
You would. But the documents describe something closer to chaos. In one case, Moreno v. IGP, a filing was flat-out rejected by the court because of e-filing ignorance.
Wait, e-filing ignorance for a computer engineer?
That's what the record says. And it's not a one-off. We see calendaring failures in Zanofsky v. Hoyt, which means missing court dates. We even see address failures in Lizeth Arroyo v. Walmart, where he allegedly couldn't even maintain basic contact info. And that's competence, Rule 1.1.
Yeah.
I think people assume competence is about being smart. But in law, so much of it is just logistics.
It's exactly that. Can you get the right document to the right place on the right day? If you can't, nothing else matters. But we need to pivot.
Okay.
Because the allegations move from basic incompetence to something far more serious. We're talking about the duty of candor.
Lying to the court.
Essentially, yes. The analysis focuses on a case, Xuan Liu v. Fernandez. He was facing sanctions, he had to appear in court, and he allegedly told the court he couldn't, claimed physical or mental incapacity.
The I'm too sick to work defense.
A perfectly valid defense. The problem, as the investigation alleges, is that records show he was actively filing documents in other cases during that exact same time period.
Wait. So he's telling one judge, I'm totally incapacitated, while he's over here filing motions in Ruvula v. Walmart and Kelly Lim v. Marriott.
That's the allegation. And the source material calls this the smoking gun.
I can see why. That's not just bending the rules. That's bordering on fraud upon the court. It violates Rule 3.3, candor toward the tribunal.
It does, and it fits this whole pattern the state bar is looking at. Frequent sanctions in L.A. and Riverside counties just failing to show up in court in cases like Remy and Robinson. It paints a picture.
A picture of a practice that's scaled its marketing way beyond its ability to actually, practice law.
The biker lawyer looks great on a billboard, but if the engine's broken, you're not going anywhere.
So true. So here's the thought we want to leave you with. You see those ads that promise you pay absolutely nothing up front. But at the hidden cost of that free representation is that your case might be abandoned because of a simple calendaring mistake. What's the true price you're really paying?
That's the question every single client needs to ask.